In September 2022, police stormed the Las Vegas home of Air Force Commander Kevin J. DeFalco, shattering the image of a decorated officer once trusted with the Thunderbirds. For many years, he held positions of responsibility and respect. At one point, he even worked with the Thunderbirds, the Air Force's aerial demonstration team, serving as an operations officer. Colleagues and subordinates saw him as decorated and moving upward in his career. But beneath that reputation was a troubling pattern of behavior that would eventually lead him into a military courtroom. His birth date and early family background are not publicly available. News coverage does not share details about his parents, childhood, or relatives. Some unverified mentions exist on social media, but none are confirmed. What is known is that, at the time of his arrest, DeFalco was stationed at Nellis Air Force Base in Nevada. He commanded the 57th Operations Support Squadron, which handled airfield operations, flight scheduling, and coordination of airspace. Concerns first came to light in the year 2022. A school counselor was informed by a student about inappropriate behavior from DeFalco. The student said that, from December 2021 to June 2022, he had contacted her through Snapchat, sent inappropriate messages, mailed her lingerie, and pressured her to wear it. A note that came with one of the packages reportedly said he wanted to see her in the clothing. The student also described a tattoo in his private region. That detail later helped investigators confirm his identity. After the counselor was alerted, she contacted local authorities. In September 2022, the Las Vegas Metropolitan Police Department took DeFalco into custody. He was first charged in Las Vegas Justice Court with 7 counts of indecent acts in the presence of a minor and 1 count of child neglect. Later, the case was transferred to the military system. In April 2025, it was reported that he faced military charges. These included misconduct toward a minor, indecent behavior, exposure, false testimony, conduct unbecoming of an officer, and possession of prohibited images. The charges had been dropped without prejudice in June 2024, which meant they could be brought again. They were indeed refiled in December 2024. By March 2025, the Office of Special Trial Counsel sent the case to a general court-martial. The court-martial lasted about 2 weeks. A military judge oversaw the trial. The prosecution presented evidence covering 17 separate charges under 6 different articles of the Uniform Code of Military Justice. The convictions included misconduct toward a minor, indecent exposure, perjury, unbecoming conduct as an officer, indecent behavior, and receiving prohibited images. The actions took place in or near Las Vegas, Nevada, San Antonio, Texas, and Fort Collins, Colorado. All of these acts involved a single victim. The fact that they occurred across different states showed the broad extent of his actions. The defense likely questioned the credibility of the evidence and the communications presented, though the exact arguments are not publicly available. In the end, the judge sided with the prosecution and found him guilty on all charges. On September 24, 2025, the sentence was announced. He received 12 years and 6 months of confinement. He was dismissed from the Air Force. He lost all pay and allowances. He also received a formal reprimand. These penalties showed how seriously the Air Force viewed his actions. Next is a very different, but no less tragic story. A young lieutenant convicted for ending the life of his 5-week-old son. David A. Valois was a young second lieutenant in the U.S. Air Force. He was stationed at Wright-Patterson Air Force Base in Ohio when the events took place. In October 2005, his baby son, only 5 weeks old, lost his life after suffering severe head injuries. The child's name was Andre Valois, recorded in court papers as AV investigators later determined that the baby had suffered blunt trauma to the head. Valois had been taking care of the child. He was frustrated because the baby was crying and could not be soothed. According to evidence shown in court on October 3rd, Valois repeatedly hit the child's head. The blows were strong enough to cause devastating injuries. The next day, life support was removed, and the infant passed away. Valois was first charged in November 2005 under Article 118 of the Uniform Code of Military Justice. At the start of his military trial in June 2006, he pleaded not guilty to the main charge, but he did plead guilty to a lesser charge of involuntary manslaughter. The judge, however, was not limited to this plea. After reviewing the evidence, the judge found him guilty of the higher charge, calling it an act dangerous to another and showing disregard for human life. Why did the court reach that conclusion? Under military law, even if the accused pleads guilty to a lesser offense, the judge can still rule based on the facts. The judge looked at the repeated strikes to the infant's head, the seriousness of the injuries, and the disregard shown. That was enough to support the higher conviction, instead of an accidental or careless act. So why did Valois admit only to manslaughter? His defense likely thought that was the best option to reduce punishment. But the judge was not bound by that choice. The record shows that the judge thought carefully before reaching a conclusion. Lieutenant Cole Gary Jackson, the military judge, took about 40 minutes after the closing arguments to decide the verdict. Air Force sources later explained the possible maximum penalties. For this offense, the punishment could include dismissal from the service, life confinement with or without parole, loss of all pay and allowances, and a fine. The sentencing followed right after. The judge sentenced Valois to dismissal from the Air Force, loss of all pay and allowances, and 50 years of confinement. However, before the sentence was finalized, a pretrial agreement reduced the confinement to 25 years. This meant instead of serving 50 years, the approved term was 25 years. After the convening authority confirmed the sentence, the case automatically went to appellate review as required under military law. On appeal, the Air Force Court of Criminal Appeals upheld both the conviction and the sentence. Valois then requested reconsideration, but it was denied. He later asked for review by the Court of Appeals for the Armed Forces, but that request was also refused in 2009. Later, he challenged the way his good conduct time credits were applied. He argued he should receive more credit for each month served. Civilian courts rejected his claim. They explained that the changes to the credit system had already been in place before his offense, so they did not violate the law. Now meet a senior officer who hid illegal acts online and secretly photographed minors. Mark Visconti had built a long and respected military career before it all collapsed. He graduated from the U.S. Air Force Academy in 1993, later serving in important roles including Special Operations Instructor Pilot and Arabic linguist. Over time, he rose to the rank of colonel. At the time of his arrest, he was serving at the Pentagon as chief of the Counter-Small Unmanned Aircraft Systems Task Force. His career also earned him commendations such as the Bronze Star. But by 2016, investigators uncovered conduct that would destroy both his career and his reputation. Federal authorities found that Visconti had been seeking prohibited material through hidden online networks designed for anonymity. A forensic review of his laptop confirmed that he had accessed and downloaded content that violated federal law. The investigation also revealed that he had taken hundreds of inappropriate photographs on his cell phone. Many of these images focused on underage individuals in exploitative ways, often without their awareness. In his plea agreement, Visconti admitted to taking these photos and acknowledged that the subjects were unaware they were being photographed. Why would a senior officer with decades of service risk everything in this way? Records show it was not a one-time lapse in judgment, but a deliberate pattern that lasted for months. His use of anonymous networks and hidden photography demonstrated planning and intent, not accident. On October 4, 2019, Visconti pleaded guilty in federal court. He admitted to obtaining illegal material online and to secretly photographing underage individuals in ways the law classifies as exploitative. By entering this plea, he avoided the possibility of a longer trial and harsher sentence. During sentencing, prosecutors emphasized both the online downloads and the photographs, arguing that his actions caused real harm. The government asked for nearly 10 years in prison. On January 31, 2020, U.S. District Judge T.S. Ellis III sentenced him to 5 years in federal prison. He was also ordered to serve 15 years of supervised release after his release, pay restitution to victims, and complete community service, including speaking or writing about the consequences of his actions. The outcome reflected both the severity of his conduct and the realities of a plea deal. What could have been a decades-long sentence instead ended with 5 years of confinement, but the permanent loss of career, reputation, and freedom. Now, what does it take for a two-star general, one of the Air Force's most trusted leaders, to become the first in history convicted at a court-martial? William Theodore Cooley worked his way up through the U.S. Air Force. He became a two-star general and eventually served as commander of the Air Force Research Laboratory. His career was long, decorated, and full of technical success. But instead of ending with honor, it ended with disgrace. The question is, how did such a high-ranking officer, trusted by many, get involved in a case that made history? Cooley's background does not show early trouble. He was born in Fort Worth, Texas in 1966. He went to Highland High School in Albuquerque, New Mexico. In 1988, he earned a bachelor's degree in mechanical engineering from Rensselaer Polytechnic Institute. 2 years later, in 1990, he completed a master's degree at the University of New Mexico. He entered the Air Force through ROTC. Over many years, he built up a strong record of leadership, technical roles, recognition, deployments, and promotions. But everything changed in August of 2018. On August 12th, Cooley attended a family barbecue in Albuquerque, hosted by his brother and sister-in-law. Later that evening, his brother's wife offered to drive him to his quarters. During that drive, Cooley allegedly forced a kiss on her. Reports said he pressed his lips onto hers while pushing her toward the car window. Prosecutors claimed he also tried to make her touch him inappropriately, and that he touched her in ways she did not agree to. They also said he used crude language to show his interest in her. Prosecutors argued that this was not sudden. They said Cooley had long imagined being with her and that this night was when he acted on it. They also said he had written emails to himself, later deleted, that showed his intent. He even wrote a note to his brother and sister-in-law. In it, he admitted he was shocked at himself for hurting them, for his own selfish ego. The case did not come forward right away. The woman waited until December of 2018 to report what happened. She later said she felt guilty for not speaking up sooner, but eventually decided she needed to. January 2020, the Air Force removed Cooley from his command at Wright-Patterson, citing loss of confidence and an ongoing investigation. In late 2020, formal charges were brought under Article 120 of the Uniform Code of Military Justice. These charges included 3 counts of unwanted contact. One was for the forced kiss. The other 2 were for inappropriate touching. Cooley said he was not guilty of all charges. He chose to face a trial with a military judge rather than a jury, which was unusual for someone of his rank. His defense argued that the kiss had been consensual and denied the other claims. The woman, however, testified that she resisted, that she never agreed, and that Cooley had taken advantage of the situation. The trial began on April 18, 2022, at Wright-Patterson Air Force Base in Ohio. It was overseen by military judge Colonel Christina M. Heinous. Evidence and testimony were presented over several days. The woman and her family gave statements about the impact of what happened. Cooley also made an unsworn statement during sentencing. After hearing everything, Judge Heinous gave her decision. She found Cooley guilty of the unwanted kiss, but not guilty of the 2 touching charges. This was historic because it marked the first court-martial conviction of a U.S. Air Force general officer. Sentencing took place on April 26, 2022. The judge gave Cooley a public reprimand and ordered him to give up $10,910 of pay per month for 5 months. This totaled about $54,550. The government had asked for stronger punishment, including demotion, dismissal, or confinement, but the judge did not go that far. At trial, Cooley had faced a maximum punishment of dismissal, total loss of pay, and up to 7 years in confinement. In the end, the Air Force Secretary ruled that Cooley would not retire as a general. Instead, he would retire in the last rank where he had served satisfactorily, which was colonel. This change cut his pension and benefits by a large amount. On May 31, 2023, it was officially announced that Cooley would retire as a colonel, effective June 1, 2023. During sentencing, Cooley made a final statement. He said, "I can honestly say I have come out a better human being than I was in 2018. I will work for the rest of my life to be a better person than the one who was portrayed in this trial. That remains the clearest public reflection he has given. Next is a case where a court-martial verdict was later set aside by a commander, a decision that sparked wide debate. And if you find stories like this important, consider subscribing. James H. Wilkerson was a career Air Force officer and an F-16 pilot. He eventually rose to the role of Inspector General of the 31st Fighter Wing at Aviano Air Base, in Italy. In the year 2012, his career took a sudden downfall. The U.S. Air Force Office of Special Investigations opened an inquiry after a female civilian worker at the base came forward. She said that after a social gathering at Wilkerson's home, she stayed overnight in a guest bedroom. According to her, sometime in the early morning hours, he entered the room and acted inappropriately toward her while she was asleep. Wilkerson and his wife denied these claims. He said he had been asleep in his own bed the entire night. His wife added that she told the woman to leave the house when she became noisy. The case went to a general court-martial later that year. In November 2012, Wilkerson was found guilty on 5 counts. These included 2 counts under Article 120 for unwanted contact and aggravated misconduct, and 3 counts under Article 133 for behavior unfit for an officer. The central claim was that the woman awoke around 3 o'clock in the morning in the guest bedroom to find Wilkerson touching her inappropriately. The trial focused heavily on credibility. On one side was the woman's testimony. On the other was Wilkerson's denial, supported by his wife's statement, along with disputes about the house layout, timing, and opportunity. Wilkerson received a sentence of 1 year in confinement. He was dismissed from the Air Force, which meant losing all rank and military privileges, and he also lost pay. But the story did not end there. Just a few months later, in February 2013, Lieutenant General Craig Franklin, the convening authority over the 3rd Air Force, stepped in. Using his power under Article 60 of the Uniform Code of Military Justice, he set aside the conviction. Franklin said the evidence was not strong enough to prove guilt beyond a reasonable doubt, and he dismissed the charges. Why would he do that after a court-martial verdict? Franklin explained, though only in brief. He said credibility played the biggest role. He believed Wilkerson and his wife more than the accuser. He also thought inconsistencies in the accuser's statements about the house layout and timing weakened the case. That decision caused a wave of backlash. Many saw it as favoritism that undermined justice, especially in a case like this. Members of Congress demanded answers. The Secretary of Defense at the time, Chuck Hagel, ordered a review of both the case and of the Article 60 powers. He wanted to know if commanders were using this authority properly and openly. In media interviews, Wilkerson said he had been dragged through the mud to satisfy political agendas. He claimed he was only fighting to clear his name. Because Franklin's decision erased the conviction, Wilkerson did not serve the full sentence. He was allowed back on active duty. However, his career soon ended in another blow. He was later reduced in rank to major and forced into retirement. This came after it was discovered that he had been involved in an extramarital relationship earlier and fathered a child outside his marriage. The next man wore the image of a trusted veteran, yet behind closed doors, he built one of the longest hidden betrayals in Air Force history. Paul Delavan Noak was once thought to be a respected veteran. He was a retired United States Air Force lieutenant colonel. In his later years, his life took a very dark turn. By the time authorities caught up with him, Noak was living in Asheville, North Carolina. He was 77 years old when he was sentenced in the year 2019. Noak's actions had 2 main sides. First, there was the long-term mistreatment of young people who were placed under his care. Second, there was his large digital collection of illegal material involving minors, which he also shared with others. For decades, these acts took place in secret, hidden behind his image of respectability and authority. According to court records, it began with the exploitation of vulnerable children. Over more than 30 years, he harmed at least 8 young people. The phrase, "entrusted in his care," was used many times in the prosecutor's account. This meant children he was responsible for in some way, whether as a mentor, teacher, caretaker, or in other trusted roles. When he was not directly harming children, he used computers and devices to collect illegal images and videos of young boys. He also shared this content with others online. Government investigators estimated that Noak had committed more than 1,500 harmful acts against minors over the course of decades. In June 2017, investigators discovered that Noak was viewing illegal content. A search warrant was issued for his home. Multiple agencies worked together on the case. These included the FBI, Homeland Security Investigations, the Air Force Office of Special Investigations, and local police. During the search, they seized computers, thumb drives, storage devices, and even printed material. A forensic review showed the full extent of his activity. It revealed not only viewing, but also active sharing and distribution of this content. In August 2018, Noak admitted to his actions. He pleaded guilty to 5 counts of receiving illegal material, 3 counts of distributing it, and 1 count of possession. But he also went further. He confessed to the direct mistreatment of at least 8 minors over the years. He admitted that for decades he had hidden behind his good reputation to continue this behavior. The question remains, why would a retired officer, someone who once held a position of authority and responsibility, do this? The official records did not go into psychological reasons, but the pattern was clear. When he did not have access to victims, he turned to his screen. When he had access again, he went back to direct harm. His high rank and reputation may have helped him hide for so long. His trial did not receive much public attention because he pleaded guilty, but his sentencing hearing revealed the severity of his actions. U.S. District Judge Martin Reidinger presided over the case in the Western District of North Carolina. Prosecutors asked for a strict sentence. They argued that Noak's actions were not isolated events, but a long betrayal of trust. On May 2, 2019, the judge sentenced him to 15 years in prison. He was also ordered to serve a lifetime of supervised release after that, along with mandatory registration as an offender. There was no leniency. The court record made it clear that federal sentences do not allow parole. Noak had already been in custody since June 2018. He was later moved to the Bureau of Prisons to begin serving his sentence. The punishment was designed to keep him under strict control for the rest of his life. The downfall of the next man wasn't just about a single mistake. It revealed a years-long pattern hidden in plain sight. James W. Richards IV was a career Air Force officer. He held the rank of lieutenant colonel. Outside of his military service, Richards also had a law license in Texas. That license later came under disciplinary review after his convictions. His record before the charges did not bring him national attention. Everything changed once the allegations came forward. The acts he was accused of were among the most serious ever handled in an Air Force court-martial. He faced charges that included repeated misconduct with underage boys and possession of inappropriate material involving children. These were not claims of a single mistake. They pointed to a pattern of behavior that lasted for years. The trouble started, or at least became visible, when the Air Force Office of Special Investigations received a tip in April 2011. The tip came from the National Center for Missing and Exploited Children. It claimed Richards had been involved in improper behavior with a boy in the past. This tip opened a much deeper investigation. Over time, investigators found that Richards had been in an inappropriate relationship with a teenager. He also sent explicit online messages. At least one of his former mentees from a Big Brother's program also came forward with allegations. As investigators searched through his online activity, the case kept expanding. In November 2011, with a warrant in hand, the Air Force searched his on-base home. They seized several hard drives. Those drives contained thousands of child-related images. In later searches, even more material was found, which made the case stronger. One of the charges alleged that in October 2006, Richards forced a minor to touch him in an inappropriate way. Other charges said he broke direct orders not to contact mentees or their siblings. Despite those orders, he continued to communicate with them. His reasons were never fully explained. In court, Richards denied many of the allegations. He also challenged how the evidence had been gathered. The government argued that he misused his trusted position in mentoring programs. They said he took advantage of that trust to pursue inappropriate acts and to exchange illicit material. The appeals that followed focused mostly on legal procedures. not on his personal motives. The trial was held at Tyndall Air Force Base in Florida. It began on February 21, 2013. The case was heard by a military judge without a jury. Richards was charged with possession of child material, multiple counts of indecent acts with a male under 16, and several counts of disobeying lawful orders. He pleaded not guilty to many charges. The judge found him guilty on all counts. The sentence was dismissal from the Air Force, which is the officer's equivalent of a dishonorable discharge. He was also given 17 years of confinement and lost all pay and benefits. The convening authority approved the sentence as it was handed down. Richards appealed to the Air Force Court of Criminal Appeals. On May 2, 2016, that court upheld both the guilty findings and the sentence. His lawyers raised issues about how evidence was handled, the scope of the search warrant, and other procedures. The court said none of those issues were enough to overturn the case. The case then moved to the U.S. Court of Appeals for the Armed Forces. That court also upheld the conviction and sentence. One of the questions they reviewed was whether the November 9, 2011 search warrant was too broad because it did not limit the dates of communications being searched. The court decided the warrant was acceptable and said any broadness did not harm the case. Richards then asked the U.S. Supreme Court to review the case. The court denied his petition. His conviction and sentence remained final. After that, Richards tried to push for a recalculation of his good time credit, which would have reduced his confinement under certain rules. Multiple courts rejected those requests. As of now, Richards continues serving his 17-year term. His release will depend on the official schedule and any earned time credits. Richards abused his position to exploit teens and hoarded illegal images. That pattern leads to a different kind of fall. Coming up is a person whose case adds claims of misconduct, false statements, and mishandled classified material. Most court-martials end on the base where they begin. So how did the next man's conviction end up rewriting law at the Supreme Court level? Humphrey Daniels III was a lieutenant colonel in the United States Air Force. His career placed him in trusted positions. By the mid-1990s, he was stationed at Minot Air Force Base in North Dakota. Very little is publicly known about his birth date or his early family life. Records outside his military career are limited. What is known, however, is the series of serious charges that later brought him to trial. The central accusation against Daniels goes back to 1998. At that time, he met a civilian woman, referred to in records as TS, at a gym. Their interaction started casually when they exchanged phone numbers. Over time, Daniels repeatedly asked if he could visit her home. He even asked to stay overnight. TS resisted his requests. She explained that her child already shared her bed, leaving no space for another adult. Daniels kept asking. Eventually, she gave in and allowed him to stay. On that night, Daniels went to her home and spent time there. TS later stated that he forced himself on her. She said that what happened was without her agreement. This accusation became the core of the case against him under military law. But this was not the only charge Daniels faced. He was also accused of dereliction of duty. That charge said he had taken classified materials home and left them unattended. This violated the strict rules of handling such documents. He was further accused of conduct unbecoming of an officer. These counts included making false statements to Fairfax County authorities in December 2014. He also misled another colonel about the reason he was requesting emergency leave. His trial began on June 5, 2017 at Joint Base Andrews in Maryland. The panel consisted of 8 officers. During the trial, TS testified and other evidence was presented. The case also showed Daniels had lied in later interactions with authorities. It also showed his careless handling of sensitive documents. The prosecution argued that Daniels' pattern of dishonesty added weight to the main accusation. The defense argued that too much time had passed, weakening the reliability of memory and testimony. Daniels pleaded not guilty to the main charge. His lawyers pushed to dismiss it, saying his right to a speedy trial was violated and that the statute of limitations had expired. On June 14, 2017, the court-martial found Daniels guilty of the main accusation, dereliction of duty, and multiple counts of conduct unbecoming. His sentence was confinement for 3 years, dismissal from the Air Force, and a formal reprimand. The convening authority later approved a reduced sentence. His confinement was lowered to 2 years and 252 days. Because officers are not demoted by dismissal, his rank stayed the same. However, the dismissal meant he risked losing retirement benefits if it was upheld. The defense strongly objected to the main charge because of the statute of limitations. Under military law at the time, most offenses had a 5-year limit, unless classified as carrying the maximum possible penalty. In 1998, the Manual for Courts-Martial placed the main accusation in that category. This meant no time limit applied. The defense argued that later legal decisions changed that standard. In United States v. Mangajas in 2018, the Court of Appeals for the Armed Forces ruled that such cases were no longer considered offenses carrying the maximum penalty for time limit purposes. This meant the 5-year limit applied. By that logic, Daniels' charge expired in 2003, long before the 2016 indictment. In 2019, the Air Force Court of Criminal Appeals agreed. They said the main conviction had to be set aside because the time limit had passed. The court dismissed that charge with prejudice, meaning it could not be retried. The other convictions remained, but the case was sent back for resentencing on those reduced charges. The Judge Advocate General of the Air Force later certified the case for review by the Court of Appeals for the Armed Forces. The government argued that the earlier interpretation was wrong, and the main charge should not have been dismissed, but the higher court affirmed the lower ruling, leaving the dismissal in place. Then came the Supreme Court's involvement. In United States v. Briggs, which included Daniels' case, the court ruled unanimously that military cases of this kind committed between 1986 and 2006 could be prosecuted at any time. Congress had clarified the law in 2006, making sure that no time limit applied. This decision reversed the earlier rulings. The Supreme Court restored the conviction against Daniels, confirming that the technical dismissal should not have erased it. As a result, Daniels' main conviction and sentence were reinstated. Senior Airman Philip Warren was 24 years old at the time of his trial in the year 2011. He served as a materiel maintenance specialist with the 49th Logistics Readiness Squadron at Holloman Air Force Base in New Mexico. Everything changed when Warren was accused of several very serious violations. These included attempted premeditated taking of life, causing severe bodily harm, leaving his post without permission, and taking a vehicle that did not belong to him. The government argued that these actions were not sudden or impulsive. Instead, they believed they were planned, deliberate, and carried out with intent. The most serious charge involved the attempted taking of another person's life. According to trial records, Warren confronted another individual on or near the base. Evidence showed that he intended to end that person's life. Witness testimony and forensic details were presented, along with Warren's movements in the days before the event. During this encounter, he caused major injuries that left lasting harm. The documents do not clearly state whether these injuries came from a firearm, sharp object, or physical force. What is clear is that the wounds were serious, long-term, and potentially life-threatening. Alongside this, Warren had left his assigned duties without permission. This meant he abandoned his post, which is a grave offense in the military. In addition, he took a vehicle that he had no authorization to use. This could have been done to move between locations connected to the violent act or to avoid being caught. The combination of harming another person, abandoning his duties, and using property that was not his made the case especially severe. As for motive, it was never fully explained in public records. Some speculation points toward a personal conflict, perhaps related to a relationship or an argument that grew out of control. However, the official summary did not go into detail. The government may have presented more information through witness accounts or prior disputes, but much of that remains locked away in military files. The case went to a general court-martial, which is the highest level of military trial. Prosecutors laid out their version of events, showing that Warren planned and carried out violent actions while also misusing military property. The defense team likely tried to argue against intent, questioned evidence, or asked the court to consider stress or mental state as factors. In military court, the burden rests on the prosecution to prove guilt beyond a reasonable doubt. The court ultimately found Warren guilty of all the charges. This included attempted premeditated taking of life, causing serious bodily harm, leaving his post without permission, and wrongfully using the vehicle. The verdict showed that the court believed Warren's actions were not random, but carefully thought out. On March 2, 2011, the sentence was announced. Warren received 22 years of confinement. He was dishonorably discharged from the Air Force, reduced in rank to E1, and stripped of all pay and allowances. The punishment reflected not only the injuries caused, but also the betrayal of military duty. At the time of his sentence, Warren was 24 years old. If he is still incarcerated today in September 2025, he would be about 38 years old. His actions left behind a trail of devastation. One person gravely injured, stolen property, and abandonment of his military duties. For years, the next individual rose through the ranks, but one trail of online activity was enough to bring it all down. Colorado. William R. Jones was a senior officer in the U.S. Air Force. He once served as the vice commander of the 20th Fighter Wing at Shaw Air Force Base in South Carolina. Holding the rank of colonel carried with it high responsibility, leadership, and trusted access to sensitive information. Over his career, Jones rose through the ranks, earned command positions, and built a reputation of authority. But his name became publicly known, not for military achievement, but for a court-martial that revealed the double life he had been living. Very little is known about his early life, family, or exact birth date. Public records focus almost entirely on his legal downfall. What is clear is that by early 2016, investigators had traced suspicious online activity to computers inside his home. On February 11th of that year, agents from the Air Force Office of Special Investigations executed a search warrant. With Jones's consent, they collected multiple electronic devices, including computers, hard drives, and a personal phone. He even provided his own passwords. The devices were then analyzed at a military digital forensics laboratory. The results revealed an extensive digital collection of prohibited material, much of it hidden, renamed, or stored in obscure locations. Forensic examiners also discovered that Jones had installed specialized programs designed to wipe files, disguise folders, and erase traces of online activity. Even so, investigators were able to reconstruct what he had been hiding. During questioning, Jones admitted that while browsing online material, he had deliberately crossed into illegal territory. He acknowledged that some of the files were saved intentionally, even though he knew what they contained was against the law. His own statements, combined with the recovered evidence, showed that he had tried to cover his tracks but could not escape detection. The question that lingers is why a senior officer with decades of service and a trusted security clearance would take such risks. Records suggest this was a personal compulsion rather than anything tied to military duty or financial gain. But the betrayal of trust and harm of access were serious violations that demanded accountability. In March 2017, Jones faced a general court-martial at Shaw Air Force Base. He pleaded guilty, under a pretrial agreement, to one count of wrongful possession of prohibited material in violation of the Uniform Code of Military Justice. The presiding judge sentenced him to 1 year of confinement and removal from the Air Force. Jones later appealed, claiming that his trial record was incomplete, that the punishment was too harsh, and that his defense had been restricted. But the Air Force Court of Criminal Appeals rejected those arguments, ruling that the evidence and sentence were appropriate. His conviction and punishment were upheld. In the end, Colonel William R. Jones went from a trusted leader with access to sensitive operations to an officer dismissed in disgrace. His case showed how quickly a career built on authority and responsibility can collapse when personal choices cross the line into criminal misconduct.